I would like to welcome everyone to the Employment Rights for People Touched by Cancer webinar program today, Tuesday, July 14, 2015. This program is being sponsored by the U.S. Business Leadership Network. It is also sponsored by Workplace Transitions for People Touched by Cancer at www.workplacetransitions.org, which is a collaboration of Anthem, Inc., Cancer and Careers, Pfizer, CEDO, an affiliate of American Institute for Research, and the U.S. Business Leadership Network. Our presenter today is Barbara Hoffman. She's on the law faculty at Rutgers Law School. I'm just going to read a little bit about Professor Hoffman. She's a member of the faculty of Rutgers Law School. She's the founding chair of the National Coalition for Cancer Survivorship and a member of the National Cancer Legal Services Network. She's the editor of 3 editions of a consumer health book and is the author of book chapters, articles, and web content on the legal rights of people with disabilities and on cancer survivorship. At this point in time, I would like to welcome Professor Hoffman, and I will turn over the microphone to you.
Good afternoon. We've seen we've really come a long way in addressing the needs of cancer survivors. And as such, we've seen improvement in their survival rates. We've seen improvement rates in the quality of life. So as a result, more cancer survivors are able to return to and stay at work. So today we're going to cover some of the issues that they face. We're going to talk about the types of problems people who have cancer experience when they are at work or return to work, what laws govern their rights at work, and what employers can do to protect the rights of employees who are touched by cancer. So let's first start with some of the employment problems that those with cancer do face. Work is obviously very important. About 1/2 of the 14 million cancer survivors in the United States are of working age. And it's obviously essential, work for everyone is so important that it provides income, provides health insurance, and is really an essential part of adult self-esteem. But cancer can affect an individual's ability to work. The most obvious is it affects you when you're undergoing cancer treatment, but it can also affect your ability to work either immediately after treatment or even in the long run as a result of late effects or secondary effects of treatment. There are many factors that affect a cancer survivor's ability to work. And some of those really depend, they're very individualized, but they also depend on things like the employee's age, the type of cancer he or she has, and that can vary tremendously. Some cancers that more severely affect an individual's ability to work include late-stage cancers or brain cancer or lung cancer. But there are many other types of cancer that have a minimal impact on an individual's ability to work, and that can include early-stage cancers, some breast cancers, and testicular cancer. So it's very individualized. It just depends on the person's individual health, their stage of their cancer, and other effects of that cancer and their treatment. But there are also a number of socioeconomic factors that affect the ability of someone to continue to work while they're undergoing cancer treatment or after treatment. And again, that's very individualized. It depends on someone's financial status and their ability to take off time from work, depends on their education, depends on whether you have access to health insurance, access to transportation, the level of cancer care you're getting, and the individual job function someone is able to do and what part of their job is. So there's really no one-size-fits-all to the kinds of problems that employees face when they're treated with cancer and what the best way to address those are. So we're going to talk about, some of the typical situations that employees encounter and what we can do to make their lives better. So most cancer survivors actually are able to work. Studies have shown that the ability to work might be immediately interrupted by a diagnosis or initial treatment, but a majority of adults who are working when they are diagnosed are able to return to their work. And their employment rates really improve as the time passes after their cancer treatment. Most cancer survivors are also treated fairly at work. Over the years, we've had much better experiences in how survivors are treated. Blatant discrimination is very rare now, and many factors have led to an improvement in the status of survivors at work. So, for example, we've improved medical care. Its outcomes are better. Cancer treatment can be provided at a little more flexible times, such as on weekends or in the evenings. So improvements in medical care have reduced the problems that survivors have faced at work. Another thing that has helped is an expansion of legal rights. And we'll talk about those rights in a minute, but they have made a significant change in how employers perceive their employees with cancer and how they're able to continue to do their jobs. And another thing that's helped is we sort of destigmatized cancer over the years. A whole generation ago, we wouldn't even be having this discussion. People were not public about having cancer. It was considered a very private thing. There was the stigma that equated cancer with death, and all that resulted in sort of a snowballing of other problems, including problems at work. Unfortunately, we've moved past that, and the destigmatization of cancer has really helped improve survivors' rights. And then finally, employers are far more educated. They're better aware of their employees' needs and of their legal rights. So that brings us to the balance of today's program, which is what are those rights? How do cancer survivors fare under the laws? And we're going to focus mostly on federal laws, since federal laws apply uniformly throughout the United States. I will briefly allude to some of the state laws that also do provide additional protection. So we're going to cover three major federal laws that really provide cancer survivors with the most comprehensive job protection. And those are the Americans with Disabilities Act, the Family and Medical Leave Act, and the Genetic Information Nondiscrimination Act, which is known as the acronym GINA. So let's start with the Americans with Disabilities Act, the ADA. That's really the most comprehensive anti-discrimination law based on medical needs, medical situations that we have. The ADA covers all employees who work for employers who have at least 15 workers. So it covers primarily moderate and large-size employers. There are some state laws that are even more comprehensive in that they are similar to the ADA, but they may cover smaller employers, even down to someone who just works for one other person. So the main purpose of the ADA is it requires employers to treat their employees based on their abilities to do their jobs and not based on sort of individual circumstances such as a medical diagnosis, and specifically here, such as having a diagnosis of cancer. So an employer could not treat someone who either has cancer or who has a history of cancer differently from other employees in the same situation. And that would cover treatment and all sorts of decisions, including hiring decisions and terms and conditions of employment. So that means when hiring a candidate for a job, an employer may not ask an applicant sort of a generic, have you ever had cancer? An employer has the right to know if an applicant is qualified for a job, if can do the skills of the job, if you have the educational background and the necessary qualifications for a job. But employers may not ask sweeping questions about an applicant's health history unless it's absolutely necessary for the safe performance of the job. And those situations are actually quite rare. So in most circumstances, it means an employer would not have the right to know if a candidate has cancer or has a history of cancer until after the employee has been hired, and then that would really only be for the purposes of filling out insurance information, or if there's something unusual about the job where a safety situation is required. So the main functions of the ADA is to protect individuals who have a disability, who are able to perform the major functions of their job with or without a reasonable accommodation. The term protects individuals with a disability covers most people who have had cancer. An older version of the ADA was unclear about how it covered people with cancer. A newer version of the ADA that was amended in 2008 requires that all cancer survivors are really treated equally under the ADA. The key is whether you can perform the major function of your job. So it doesn't mean that all cancer survivors are entitled to work and do their job regardless of what they're able to do. You still have to be a qualified employee, which means you're able to do the major functions of your job, but sometimes it means you need some accommodations to be able to do that. We will talk about that, what accommodations are in a moment. There's one other feature of the ADA that's very unique to a job and to employment discrimination laws. And that's because it also applies not only to the employees themselves, but it also protects applicants and employees from discrimination based on their relationship or association with an individual with a disability, even if the applicant or the employee doesn't have a disability. And that's a huge boon to caregivers of cancer survivors. So the ADA does not require a family relationship for an individual to be protected by this association provision. The key is whether the employee is motivated by the individual's relationship or association with a person who has cancer. So the purpose of this is to prevent employers from taking any adverse actions based on unfounded stereotypes or assumptions that the employee is going to need to take a lot of time off to care for their loved one. So it's unlawful to discriminate against an employee who's a caregiver of someone who has cancer, based on the assumption that they will need to take care of their loved one's needs, or they may be otherwise unreliable because they'll miss work, or even because their health insurance expenses might rise. So the ADA is really unique in also protecting, the employees who not only have cancer, but like many of us who are caring for loved ones with cancer. Now, one of the most important provisions of the ADA in relation to how it protects people at work with cancer is it requires employers to make reasonable accommodations. What is a reasonable accommodation is determined on a case-by-case basis, and it depends on factors like what the duties of the job are and how burdensome or expensive it may be to make these accommodations. But the accommodations are anything that will help the employee with a disability participate in the application process or be able to perform essential job functions. And it's really a balancing test to ensure that the employee is able to do his or her work with accommodations that are reasonable and that don't unduly affect the workplace. So some of the common types of accommodations that are helpful to cancer survivors are things like changing job duties. Some survivors are unable to perform certain physical tasks during or after treatment. And it may be that their job requires many duties, but only a few of those may be too physically demanding. So one accommodation may be to temporarily or long-term change the job duties so that the employee is able to continue to work and to continue to perform all the other essential job duties. Another real helpful accommodation is flex time. Cancer is a very time-consuming job, and it requires time for medical treatments. It can require time for follow-up visits, and often the survivor is able to continue to go to work, but occasionally needs some temporary time off. May need a few weeks off for more serious medical treatment like surgery or chemotherapy, may need time off to recover from certain treatments, or just may need a shorter time. And for example, radiation treatments now are often scheduled around somebody's work time, and it might be someone just needs a longer lunch break, or to be able to shift the time they work to come in earlier, leave a little earlier, and go to a medical treatment after work. The word flex is really key because the accommodation needs to be individualized, and flexible time can make a huge difference in allowing somebody to continue to work. Another kind of accommodation is unpaid leave. Although the ADA does not require paid leave, it does require an employer to give the same leave policy that it would to all of its employees. So if the employer does provide paid leave, then the employee with cancer would be entitled to paid leave. If the employer does not provide paid leave, then sometimes just having more flexible unpaid leave can be helpful, again, to allow time for treatment to work and to allow some recovery time for treatment. Another helpful accommodation is telecommuting. Many jobs now allow telecommuting, and it allows people who are going through cancer treatment to work from home and not worry about some of the fatigue problems associated with having to get up and drive to work, not worry about some of these physical consequences of going to treatment, going through treatment, so that getting physically prepared for work may not be an issue. So for those kinds of jobs that can be accomplished through telecommuting, many survivors are able to continue to do their work far more easily than having to physically go into work. One of the ways the ADA also affects sort of attendance and leave policies, the ADA requires that if an employer has a leave policy, it has to be given to all employees in the same way, regardless of disability. But the ADA does require employees to be flexible about how they institute those leave policies to try to make them a little more effective and accommodating for cancer survivors. So that's sort of the summary of the Americans with Disabilities Act. It is a federal law that governs all employers who have at least 15 workers. Many state laws are very similar to the ADA. Every state has some type of anti-discrimination law in employment. Many of them are modeled on the ADA, but some are not as helpful as the ADA is. Some are even more helpful. As I mentioned earlier, some state laws govern smaller employers, as many as just 1 or 2 employees. That would trigger the state law. And then some state laws also directly refer to how cancer survivors are protected under the laws. So you always have 2 levels of protection. You've got the federal level of the ADA, but depending on what state you work in, you also need to see if there's any additional requirements required by that state law. So the ADA is one of the most useful laws that govern the rights of cancer survivors at work. Another law that is very effective is called the Family and Medical Leave Act. The Family and Medical Leave Act does not apply currently to as many employers as the ADA, though Congress has frequently considered bills to amend the Family and Medical Leave Act. But this law currently only covers employees who work in places that have at least 50 workers, so it tends to cover more larger employers. What the FMLA requires is for private employers to provide time off from work to address a serious health condition. And cancer, in almost every circumstance, is considered a serious health condition under the FMLA. Employees are entitled to leave to care for either, obviously, yourself if you are the person who has cancer, but also to care for dependents, such as an ill child, a parent, or a spouse who is seriously ill, including cancer. And then the FMLA affects survivors in quite a number of different ways in how it can provide leave. The general rule is employees are entitled to 12 weeks of unpaid leave during any 12-month period. That leave can be provided in different ways. We'll get to that in just a moment. It also requires employers to continue to provide benefits, most importantly in this case, health insurance, during the leave period. So that creates a really important bridge for people to continue to have their health insurance even during leave. And then once somebody can come back to work, it requires employers to restore employees to the same position or an equivalent position if the exact same position is not available when the period of leave runs. It allows leave because a serious health condition makes the person unable to perform the functions of the position. And often during cancer treatment, at least for some temporary period, employees are unable to do their key work. But is not triggered for temporary or non-serious conditions. So what it does is allows employees to take an intermediate leave or a reduced work schedule when it is medically necessary. And you don't have to take that the leave all at once. The beauty of the FMLA is it allows some flexible time in recognizing that individuals need to take leave at different times. So some people who are undergoing treatment need to take all 3 months at once. They may have surgery, they may have grueling chemotherapy, they may not recover that well from that treatment, and do not have the kind of job that you could sort of come and go or do some by telework. So for some people, they need to take leave 3 months at a time. But for many cancer survivors, they need to take leave in smaller chunks. So you can take those 12 weeks as needed. You may just need to take a week off here and there, or 2 or 3 days off here and there, depending on the nature of your treatment. So like most kinds of accommodations, medical leave is very individualized depending on the survivor's needs, abilities, medical situation, and the job duties. The FMLA is just a floor. It permits employers to provide more leave, more generous than the 12 weeks, but at least gives sort of a base floor to all individuals. So the FMLA is a very effective way to help cancer survivors stay at work. It's very well balanced to also protect the needs of the workplace. So employees need to make at least a reasonable effort to let their employers know when they're going to need to take leave. If possible, to give them up to 30 days of notice. It's not always possible, but when that's available, to try to make it easier for employers to schedule their workers. And it even allows employees to, well, let's skip that one. Let's go to the state response to family and medical leave. Only the District of Columbia and 11 states, and those are California, Connecticut, Hawaii, Maine, Minnesota, New Jersey, Oregon, Rhode Island, Vermont, and Wisconsin. Only those states and Washington, D.C. have leave laws. Some of them are more generous than the Family and Medical Leave Act. So again, depending on where you're working, it's also important to be aware if there are local leave laws that would provide more options for cancer survivors. So that is the FMLA. Then the third federal law that helps cancer survivors at work is commonly referred to as GINA, the Genetic Information Nondiscrimination Act. That law prohibits employers from using genetic information to make any decisions about hiring, promotion, and terms and conditions of employment. That it protects employees from discrimination based on the results of a genetic test and based on information about family history of disease. But what GINA does not protect is it doesn't govern situations because an employee has a manifested disease or condition. So what it covers, the point of it is to not punish or discourage employees from getting genetic testing. So there are now an increasing number of cancers, not just breast cancer, that will have treatment based on genetic predispositions and genetic history. So for many cancer survivors, or many people who have a history of cancer, having genetic testing can be very important. So what GINA does is prohibits employers from treating someone differently simply because they've taken the test, or they've taken a test that suggests they may have a predisposition for cancer. But it does not protect someone once they have been diagnosed with a genetically related disease. Like the Americans with Disabilities Act, GINA applies to employers that have at least 15 workers. So those are the three main federal laws that protect and govern survivors' rights in the workplace. So let's go back to one of the things required under the ADA and is related to the Family Medical Leave Act, and that's accommodations for cancer survivors. This is one of the most important ways employers can help employees who have been touched by cancer. Once somebody's already been diagnosed, they do want to continue to work. And providing reasonable accommodations to employees really helps everyone. It obviously helps the employees who are touched by cancer. It helps them preserve their jobs so they can care for themselves and care for a loved one. But providing reasonable accommodations also helps employers. And it does so because people who are able to continue to work through an accommodation it increases productivity because reasonable accommodations can reduce turnover. And we have many studies, especially those that study cancer survivors, show that when people return to work and can keep their job, and therefore you're minimizing turnover rates, productivity tends to increase. So for the bottom line, providing reasonable accommodations for employees helps employers too. And finally, it also enhances goodwill in the workplace. Everybody sees how employers treat the person who has cancer, and when you're, helping somebody through a very difficult medical and emotional and financial situation, then it enhances the goodwill of everyone in the workplace, and that further increases productivity. So let's review a few of the accommodations that most help survivors. Medical leave is really probably the most important. It will help survivors, especially those who are still in treatment, to have time off from work, to schedule treatment, and to recover from treatment. Doctor's appointment, surgery, chemotherapy, radiation, medical testing, it's very, very time-consuming, and no one should have to choose between attending work in 6 hours and obtaining, life-saving medical care. So survivors who are able to both attend to their medical needs and still know that their job is going to be there usually end up, being very productive, terrific employees. Leave sharing is another very helpful accommodation. Many people who work with someone who has cancer, they want to help, but they often don't know what is the best way to help. One way is allowing coworkers to share their sick days, share their vacation days, by creating flexible rules that allow people to share sick days and vacation days. Again, it helps everyone. It helps the employee with cancer not worry about having to lose a job or have unpaid time. If they have extra vacation days, they have extra sick days. And then it helps their coworkers feel like they're being a constructive way to help someone in need. And most people feel good about helping out. A third accommodation is flex time. I briefly alluded this before, but again, cancer care is so time, takes up so much time that often those survivors who don't need weeks off at a time may just need hours off at a time, and that can make an enormous difference. For example, radiation treatments can be sometimes scheduled for late in the day, and if a survivor were allowed to work different hours, for example, work from 7 a.m. to 3 p.m. instead of 9 to 5, that might make all the difference in the world to be able to schedule radiation treatments. Medical appointments, the same thing, to be able to have certain time off during the day to accommodate medical appointments can make a huge difference. Most cancer patients spend a lot of time in a lab. Blood work and scans and x-rays are just an inherent part of cancer treatment. But again, you need a few hours off from work to be able to schedule those. So the flex time to be able to schedule those can be helpful. And then finally, even the flex time just to provide a little downtime. Cancer is an exhausting disease to treat, and loss of stamina and fatigue are very common side effects of cancer and cancer treatment. And to provide flex time to give cancer survivors a little bit of time to rest, even if it's just a few hours in the middle of the day to take a break in a restroom, can make all the difference in the world to make sure that somebody can continue to work. So flex time can include just reducing hours during the day, or even temporarily reducing a job from a full-time position to a part-time position. Telecommuting that I talked about briefly also really helps survivors because it allows them to conserve energy, allows them to work in private if they're not feeling just right or they feel like they're looking a little compromised by treatment. Some survivors also have mobility issues that can be temporary, and allowing telecommuting as a way to accommodate survivors who have mobility issues, may need a wheelchair, may have trouble walking, or may have transportation issues. And another benefit of telecommuting is by minimizing the cost and time and energy of commuting, it allows survivors to take the time and the energy that they do have and put it into working, into being a productive member of the workplace instead of losing a lot of that time and energy to commuting. Obviously, telecommuting isn't going to work with every job. Some jobs require physical attendance, things like teaching or manufacturing. There are many jobs that do require physical attendance. But more and more with technology improving, every day there are just more jobs now that we can restructure through telecommuting. And in terms of job restructuring and reassignment, some survivors aren't able to continue to perform their old jobs because of fatigue or mobility issues, or maybe compromised immunity issues, or even in cognitive limitations caused by cancer or its treatment. So for those survivors who cannot do their old jobs, then providing them a new job or a restructured job may make a difference. So for example, a job that has a physical limitation, like lifting heavy objects, may be able to shift that part of someone's job to someone else's responsibility, so the employee doesn't have to continue to lift heavy things. Another example may be minimizing travel. Many survivors could work at home or could work in an office that's close by, but aren't able to travel, may not be able to take a train or a plane for stamina reasons, for reasons needing to be close to their medical providers, also for immunity reasons. Cancer can, seriously affect someone's immune system, and you need to be out of a workplace or out of a situation like on an airplane, which could be compromising the immune system. So those are the kinds of changes you can make to someone's job duties. You could have somebody else do the travel if that is possible. And then finally, reassignment. People who can't do their job at all may need to be reassigned to a different kind of job. And depending on the employer, and again, everything is individualized, but depending on the employer, new jobs may be able to be created or shifted so that a survivor is given a new job. So when you're talking about accommodations, most of the accommodations are going to fall under one of two categories. One is to accommodate time, because survivors need to have the flexibility to handle their medical needs and balance the time it requires to attend their medical needs against the time it requires to do their job. So any kind of accommodation that focuses on shifting time, like flexible hours or part-time, can make a huge difference. Then the other kinds of accommodations focus on abilities. And again, that is very individualized. So for some survivors who have physical limits, then you need to think about what kind of accommodations can help address the physical needs. For some employees who have cognitive limits, then they may need the kinds of accommodations that address that, such as the ability to take extra notes or to record meetings. Most accommodations are very inexpensive to provide. The ADA does not require employers to provide accommodations that are unduly expensive, so much so that it would be disruptive on the workplace. But most accommodations actually don't cost anything or have minimal costs. There have been a large number of studies on, how much does it really disrupt the workplace to accommodate people with disabilities. And we now know that some sort of assumptions about, oh, this is going to be burdensome or this is going to be too expensive, we now know that's really not true. Most accommodations are very reasonable and do not cost very much. But one of the balances to that is also an employer need not accommodate someone in a situation where it might cause either risk to health and safety, or it might cause a danger to someone at work, either by health or a safety issue. So if a survivor says, they want to continue to do a certain job, but their medical consequences don't allow them to do it. So, for example, if someone drives a delivery truck, but their treatment causes episodes where they may faint, then that could cause a health and safety risk. So a survivor who says, well, I still want to be able to drive my route, you may not, as an employer, be required to then continue to say, okay, we're going to let you drive your route even if it causes a safety problem. That is a limit. So employers do not have to provide those kind of accommodations. So accommodations have to be very, very individualized, and they're significantly affected on the kind of cancer someone has and the kind of treatment they have. Some of the main things that affect what type of accommodation is appropriate may be fatigue. Different survivors need different amounts of time to rest. They may need a quiet room or some time off to rest. Another thing to accommodate is nausea. Cancer treatment and cancer itself frequently results in nausea. So to accommodate that, an employer may need to allow the employee, more time to be able to use a restroom or relocate an office to a restroom. The ability to drink ginger ale or eat crackers at work, something to address nausea. A third kind of accommodation is to address physical changes, as I mentioned, such as lifting, or you may need to have a different kind of chair or adaptive technology or ramps or whatever is necessary to accommodate physical changes caused by cancer. So those are some of the main accommodations that are helpful for cancer survivors. So just sort of in summary, most of these laws have made a huge difference for ensuring that when someone is diagnosed with cancer, that's enough of a consequence to deal with, the medical and financial and emotional costs of cancer. But laws like the ADA and the FMLA and GINA are designed to ensure that for those people who can work, we do provide them accommodations to allow them to work, and we do protect their privacy when they are at work. So now we would like to entertain any questions that you have about any of these laws or ways we can help survivors transition back into the workplace.
Great, and at this time, if people have questions, would they please submit them in the chat area, and we will direct those to our presenter. So Barbara, I've got a question for you here that came in. Second here. Are there any good ways for a manager to accommodate an employee with cancer who's been on leave and is returning to work, any suggestions that you might have in considerations of that, of somebody coming back that should be taken into consideration?
Well, the best way to determine how to accommodate someone is just to communicate and to listen. Again, the accommodations are going to focus on time and the time they need to address their medical needs and the abilities to do the specifics of their job, what their job duties are. Survivors, if an employer meets with an employee before he or she returns to work and meets, in a private place, this is not the kind of discussion you have in front of the whole office, but meets in a private place, welcomes them back nicely, and says, we want to help you transition back to work. Tell us what you need. And then does a lot of listening because it's so individualized. Some people don't want to ask for any accommodations. Some people may want to ask for more accommodations than they're entitled under the law. So the main thing is start with a private, quiet listening session that says, I want to be here to help. Let me know what we can do for you. And any of those accommodations that are reasonable and that can be worked out, to try to work them out individually with the employee. But it's so individualized, you can't really just say, you don't want to have a laundry list and say, these are the only accommodations you will get, we won't give you anything else. It's a give and take discussion to try to work out what is best for that person in that job.
Great. That just reinforces the old adage that accommodations under the ADA are very, very case by case, for sure. Someone's asked a question and referencing that you had mentioned state laws and issues with state laws. Are you aware of any pending legislation that might be at the state level across the country anywhere?
I am not aware of it. There's almost always something pending in some someplace, somewhere. For people who are interested in the medical leave issues, because those are really the ones that we don't have uniform state laws yet. The Partnership for Families website, I don't have that at the ready, but we can put that on the resources link. But the Partnership for Families is a nonprofit that advocates for medical leave and monitors state by state what leave laws are. And their website does keep track of the status of leave laws in each state. So it's Partnership for Families, which you can Google and get the website too, but I don't, off the top of my head, remember the address.
I think it's partnershipforfamilies.org.
That might be it. That sounds right.
Yeah. Yeah. And so another question here that someone has asked is that can you talk about the relationship between time off under short-term or long-term disability benefits that an employer may offer to individuals and how that interfaces with FMLA leave?
I know that some disability laws, a lot of that is controlled by state laws, and I don't want to, give legal information when I'm not really familiar with the individual state laws. But I mean, sort of how all of this relates is the Family Medical Leave Act sort of sets that base of 12 weeks of medical leave. And it relates to the ADA because medical leave is a reasonable accommodation under the ADA. So they all sort of relate to each other. They don't work in effect of, you don't add them all up and get extra leave. So it's not a cumulative where different laws give you, separate leave and you can add them consecutively and get extra leave. Each law really is it's really just 12 weeks.
Great, thank you. Yeah, it's very complicated, obviously, with that state-to-state issue with laws, and then also different employers' policies, obviously, in their short and long term. So.
That's actually a really good point that I didn't get to, which is we just talked about, the federal laws, but employees' rights are also governed by the terms of their employment. So in addition to the federal laws, employees just need to be aware of what their personnel policies are and what the leave, whether it's paid or unpaid, and the lengths of time and shared sick leave and all of that, what their employer provides. So part of the answers to every question from the employee's point of view is have a discussion with the person at work, the human relations person or whoever's in charge of it, about what the company offers, because the key is if the company offers one employee something, they have to offer all employees in that same situation, regardless of medical diagnosis.
Here's a question that often is kind of a tricky one, and you hear about it a lot from people, managers, as to what to actually do. But what should a manager tell a well-meaning colleague who wants to help that are asking for more information about an employee situation that person wants, more than that person wants to divulge? It's a tricky one.
It's a tricky one because you need a balancing test. The goal is you want to be helpful but not nosy, and the legal requirement here is everybody's got privacy rights. So both the ADA and HIPAA, the health insurance, advocacy, it's known as almost as the privacy law, HIPAA, require employers to protect the privacy of employees' medical history. So an employer can ask an employee for information about medical needs when they're relevant to the ability to do the job safely and when they're relevant to determine what kind of accommodation would be appropriate and effective. But that asking for any kind of medical information, it's got to be related to that. Otherwise, employers have to respect the medical privacy of their employees. So they really can't go telling other coworkers anything about one individual's cancer history unless that individual says it's okay, I want to discuss it. And that's a very personal thing. It's really up to the person with cancer to decide based on, the workplace environment, what they want to tell and whom they want to tell. So, some people are in a small family work environment. Everybody tells everybody everything and supports one another. If that's what the employee wants, that's fine. Other people are in an environment where they want to be to themselves. They don't want anybody knowing their personal business, and they can keep their cancer history completely private. The only people who have a right to know are the managers who have to ensure that they're getting the right accommodations. So it starts with the employer should go to the employee and say, what do you want me to say? Do you want me to tell your coworkers? Do you want me to say nothing? I will do, what you want. And they really have to respect that employee's privacy. There are actually other ways to sort of, help the coworkers when they return. Again, depending on what the employee wants people to know. One is even just to be respectful of health needs, because if you have cancer, often your immune system is a little compromised. It may be important to tell coworkers, cover your mouth when you sneeze. Don't come to work if you have a fever. Wash your hands very thoroughly before you come back to your desk. Little things like that to make the workplace a little safer. Another thing, again, if the employee says it's okay, the employer could say, look, our coworker is coming back, but she's going to need more time off, so maybe we could pool our medical leave or our sick leave or our vacation days and help her out, or we could give her more space, to work, or whatever it is. But but how the employer could help somebody returning always is going to start with ask the person with cancer what that person wants.
Great, good advice, definitely. Someone's asking if there are resources that someone should keep on hand for reference in case someone at work develops cancer, around these issues. Are there any free resources out there, anything that you would particularly recommend in that area?
Well, we have slides on that. In addition to the workplace toolkit, which I know you will talk about in a minute, we have, there are many resources. Just a few of them listed here. There are public resources, mostly by the Labor Department or the EEOC, that explain a lot of these laws in more detail. One of the best government resources is the fourth one on this slide, called JAN, which is the Job Accommodation Network. That provides great detail in explaining what kind of accommodations could be appropriate, could be required under the law, and it provides many, many examples of ways to accommodate individuals, including individuals who have cancer. It's frequently updated. It's really a fabulous website. There are many advocacy groups that provide information, one like Partnership for Family, others such as the Cancer and Careers website, the National Coalition for Cancer Survivorship website, which is canceradvocacy.org. They all provide information about sort of the practical ways to help survivors at work and more advocacy information. But one of the beauties of this, all of these websites link to each other. So once you get in somewhere, you will see links to other ones. But there's really such a wealth of information that employers really should have on hand, should make sure their human resources departments are well trained to address the needs of survivors at work, because the 14 million people in the United States, 7 million of whom are working age adults who have had cancer. More than 1 million people are diagnosed every year. So we're all encountering somebody in the workplace who has cancer, so it's good to be prepared.
Great, thank you very much. And as you said, just to reinforce, the Workplace Transitions Toolkit is a great resource as well, and workplacetransitions.org is the website where you can find that. Many of the questions and things that came up today during the session by you, the participants, as well as the issues that were discussed by Barbara, are covered on this. And again, this is a collaboration between Anthem Inc., Cancer and Careers, Pfizer, CEDAW, and the U.S. Business Leadership Network. So the sponsors of this program have great resources of their own available. I want to thank Barbara for her time and efforts today in regards to the presentation and providing us with some excellent information. The evaluation the link is here. It'll also be sent out to you by email. Please take some time to thought. Your input is very important to us as they shape additional topics and things that are happening. Save the date of October 6, 2015 for the next webinar that it will be sponsored by Workplace Transitions. They will be sending out more information and details upcoming related to that, but you might want to mark your calendars now related to that date. Also want to just remind you that the USBLN has a regular monthly webinar series for members only. The next one is tomorrow, actually, July 15th, starting at 1 p.m. Eastern Time, of which the topic is how to wow a diversity hire, the perfect recruitment and onboarding experience. And you can register for that at the link that is provided here, again, in your handout materials as well, to be able to go back and reference that and on the members only section of the USBLN website if you are a member of the USBLN. So again, thank you very much, both Barbara and you as participants, for joining us for today's session. As I said, the session is recorded and the recording will be made available at a later date, and you will be notified how to be able to access that. So again, everyone, have a great day. And you can now disconnect from the session by either hanging up the telephone, if you were on telephone, or closing your browser will also take you out of the webinar platform. Again, thank you and have a great day.